Hi, I'm Ollie, and in this Politics Explained video, I'm going to go through everything you need to know about human rights courts and human rights law in Edexcel A Level Politics. I'm going to start by having a look at the parts of the specification this video covers, before having a look at some key 12 markers and 30 markers you can use this content to answer. I'm then going to start by having a look at the origins and development of international human rights law, looking at what are human rights, how law developed, international human rights law developed, especially in the post-World War II period, and how it's enforced, before looking at four key international human rights courts. So the International Court of Justice, the International Criminal Court, the European Court of Human Rights, and finally International Tribunals, before finally looking at the impact of human rights law on state sovereignty and a number of different arguments on either side that you can use in your essays. The notes you can see on your screen are part of an updated textbook on the Global Politics section of the Edexcel A Level Politics specification that you can purchase by clicking on the first link in the description on the Politics Explained website, where you can also find loads of resources to help you in your Politics A Level, including Global Politics essay plans and 12 marker plans, essay plans covering every single part of the A Level Politics course, updated textbooks covering every single part of the A Level Politics course, a place to sign up for tutoring if you're interested, and also a place to sign up for the waitlist for some live revision webinars we're going to be doing before this year's exams and we'll be doing in future years as well. So yeah, without further ado, let's get into it. So looking at the parts of the specification these notes in this video covers. So far we've done 8 videos on the YouTube channel on global politics. The first 3 of those were on the first subtopic of global politics, and that was the state and globalization. The second were on the second topic, and that was global governance, political and economic. And now we're going to have 4 videos on the YouTube channel on human rights and environmental global governance. And this is the first of those 4. So we're going to have a look at the origins and development of international law and international human rights law, crucially looking at the key institutions I mentioned, the ICJ, the ICC, special UN tribunals and the ECHR, in creating global politics and global human rights governance. We're also going to look at the source of that, their authority in the UN Universal Declaration of Human Rights, and the relationship between human rights and sovereignty, as well as crucially some key debates on the effectiveness and impact of international human rights law and international human rights courts, particularly looking at the impact of state sovereignty and whether state sovereignty prevents them from effectively upholding human rights. So there's going to be the first of 2 videos on human rights. This first one's going to look at human rights courts, and the next one is going to have a look at humanitarian interventions. In terms of some key essay questions and 12 markers, you can get asked on this in the exam. So all of the ones in bold can be purchased on the Politics Explained website as kind of packs of 12 marker plans that are really detailed, and 30 marker plans as well. And if you know these ones in bold and plan for them really well and know the content in them really well, you should not only be able to answer those questions, these kind of key questions or variations of them, which are really likely to come up, but you should also be able to adapt that content to answer kind of any question that can come up in the exam. So some key ones you can get for 12 markers. So of course, 12 markers are really about comparing institutions, looking at similarities or differences. So you could definitely get asked to examine some of the similarities between 2 of the key courts. So for example, similar criticisms, this first one of the ICC and special UN tribunals, or you get asked to look at the differences between these different courts, for example, difference between the International Court of Justice and the International Criminal Court. And that's likely to be the key structure you're going to get asked for 12 markers on the topic of this video. In terms of essay questions, you can bring the content in this video into. So it's definitely a kind of question on the relationship between sovereignty and human rights, because the exam board have specifically highlighted that as a key debate. And then you could get one just on the effectiveness of human rights courts as a whole, so that would really just focus on this video. You could also get it maybe comparing it to humanitarian interventions, or so bring in that kind of second video as well, combining it. So you get one just on evaluate the view that human rights are upheld effectively globally, and that will bring in both content from this video, human rights courts, but also the next video on humanitarian interventions. So make sure to have a look at that as well. Yeah, starting off, we're going to have a look at the origins and development of international human rights law. And before that, we need to have a look at what human rights are. So human rights are fundamental rights and freedoms that all humans are entitled to. And this is a kind of useful definition you could bring in at the start, maybe at some of your introductions in relevant essays. So they're universal, inalienable, and indivisible. And that means universal, they apply to all people without discrimination. Inalienable, they can't be taken away except in specific situations as defined by law, for example, lawful imprisonment. And indivisible, they can't be selectively upheld. They must all be upheld. You can't just decide to uphold some human rights and not others as a government. They're classic kind of categorized into two main types, so civil and political rights, kind of classic right to free speech, fair trial, freedom from torture, and they're considered immediate obligations for states to uphold, are the most central human rights. And there's also economic, social, and cultural rights, for example, the right to an adequate standard of living, the right to healthcare, the right to education. Though they're equally important, of course, their realisation is often not as strong and can really depend on a state situation, resources, and how the state decides to act effectively. So some key human rights you definitely will have come across: the right to life, freedom from torture, freedom of speech and expression, which of course is potentially the most politically salient one that often comes up in political debates, right to a fair trial, and then some of the social ones: education, adequate housing, and health. The development of international human rights law really came in the aftermath of World War II, where of course there was widespread human rights abuses during World War II. Not only the natural human rights abuses you get during war where people die, but also the use of chemical weapons, the use of nuclear weapons. And there's a real recognition there was a need for a global system to prevent these future atrocities that were led by states. And the vision was to establish a kind of international order where fundamental human rights were safeguarded and respected by all states, and crucial to this was international human rights law. It, as we'll see, it limited state sovereignty in certain aspects, emphasising that the protection of human rights is paramount and a shared responsibility that transcends borders, and that states actually sometimes lose their right to sovereignty, complete sovereignty, if they abuse human rights. So it's designed to make very clear: you're a state, you have to uphold, you're responsible for upholding human rights, and if you don't, the international community can act. There are a number of key documents shaping international human rights law. By far the most important is the universal, and the first, and so that kind of makes it the most important, is the Universal Declaration of Human Rights in 1948, which is adopted at the United Nations, and it set out a comprehensive list of rights, including civil, political, economic, and social rights. So it's not legally binding, but it's provided a really useful universal framework that has really then strongly influenced human rights protection across the globe, including other forms of international human rights law. For example, the European Convention on Human Rights, which is linked to the European Court on Human Rights, we're going to have a look at in a bit, is very much based on the Universal Declaration of Human Rights and upholding those in a European context. There are then a number of other really important laws. You don't necessarily need to know these, but it's useful to just have a little bit of history that came in kind of influenced by the UDHR, Universal Declaration of Human Rights, and looking to continue the upholding of human rights globally. So you have some conventions that are passed by the United Nations. For example, Convention on the Prevention and Punishment on the Crime of Genocide, so very much focusing specifically on genocide as a form of human rights abuse. You also see the International Covenant on Civil and Political Rights, which kind of really builds on, and is a legally binding treaty that codifies civil and political rights. Is linked to the United Nations as well. The International Covenant on Economic, Social and Cultural Rights, which builds on that for that kind of second type of rights, and the Convention on All Forms of Discrimination Against Women, of course, another specific form of human rights abuses. But you also have some that aren't linked to the UN. As I mentioned, the European Convention on Human Rights, which is drafted by the Council of Europe and really intended to be upheld by the European Court of Human Rights in Europe to prevent human rights abuses in Europe. And then we'll look at the ICC in more detail later in the video. A really key moment in the upholding of human rights globally is the formation of the International Criminal Court in 1998 with the Rome Statute, which is a permanent judicial body with the intention of prosecuting individuals, particularly individuals within states and political groupings, charged with genocide, war crimes, and crimes against humanity. So really the worst human rights abuses. So that's the structure of international human rights law. What we're going to have a look at now is how international law is enforced, and this is really, really important, and central to this is sovereignty. When we think about law in domestic law terms, the state is empowered to enforce a law. So there are a list of rules that everyone has to follow, and if you don't follow those rules, the state in domestic law puts you in jail effectively, or fines you, or punishes you, and it does so through the police, through the judicial system, and through prisons, which really force people to comply with the law or punish them if they don't. Crucially, in international law, there isn't an overarching police force that constrains all states and actors within the international system. So ultimately, it's very much more difficult for states to be forced to comply, as states have sovereignty over their own internal affairs. There isn't this police force that can really force a state to do something. And crucially, that means that the upholding of international law is very dependent on the willingness of states to voluntarily comply due to moral pressure, and the importance they place on themselves and other states place on them of upholding international human rights. And it's also based on other states' willingness to punish a state that has violated international law in order to pressure it to comply, and that could be through sanctions or potentially through international humanitarian interventions, which we'll look at more in the next video. So there isn't a global overarching police force, therefore the upholding of human rights is very dependent, firstly, on the willingness of an individual state to comply, and if they don't comply and don't uphold human rights, the willingness of other states in the international community to enforce human rights, to act kind of as that police force. So the enforcement of international human rights law therefore faces significant challenges due to state sovereignty, and as states don't always voluntarily comply and international courts lack a police force to kind of implement it, the implementation of international human rights law is inconsistent, as can be seen in the fact that there are human rights abuses that do occur globally and often go unpunished. It was really useful to bring in here the realist and liberal perspectives on international law, which I think you do want to. Obviously, the main focus where you're looking at realism and liberalism is going to be in that second one of those 12 markers in your exam. But bringing in realist and liberal perspectives is something you're going to want to do in some essays if you're really pushing up for that A star. So realists, including, for example, John Bolton, has very specifically made that argument, effectively argue that international law isn't real law, and it means nothing and it's not effective. And this links into their overall view that state sovereignty is paramount. Nation states hold the most power and are the most important actors in global politics and international relations, and that international institutions, IGOs, international courts really have no power to constrain states. So they argue that international law isn't real law because it lacks true enforceability and relies on voluntary state compliance and moral pressure rather than coercive power of a global police force, which there isn't. They view international relations as driven by national interests, with states acting primarily to increase their power, and therefore international law is only followed by states if it's convenient and aligned with their interests. And they crucially argue that powerful states in particular can often ignore international law without facing significant consequences, as there's no superior authority to hold them accountable. Liberals very much disagree. They believe that international law is law and argue that it's often successful in shaping state behaviour through moral pressure and through diplomacy. And as a result, they see it as contributing to a rules-based international order, where states recognise that adhering to international human rights law and international law as a whole creates predictability, reduces the likelihood of conflict, and is mutually beneficial for all states. So very much disagreement on the importance of international law between realists, who argue it's not real law, has very little impact, and liberals, who really argue that it is important and is successful in shaping state behaviour. Okay, moving on now then, what we're going to have a look at is the International Human Rights Court, starting with the International Court of Justice, which we already actually looked at in a previous video when we looked at the United Nations, but we'll kind of go over it again now. So what then is the International Court of Justice? So it's also known as the World Court, and it's the principal judicial organ of the UN that was established in 1945. It's based in The Hague, in the Netherlands, and it's the only court of a universal character with the purpose of settling legal disputes between states. So crucially, it's a court for disputes between states, whilst it also provides advisory opinions on international legal matters. So what then does it do? So its key aim is to promote the peaceful resolution of disputes rather than then turning it into conflict or war. It does so through two key functions. Firstly, settling disputes. So when states bring cases to the International Court of Justice, it adjudicates based on international law between the different states. And only states can be parties in cases before the ICJ, unlike, for example, the ECHR, which we'll have a look at later in the video. Once a court reaches a decision, its judgments are binding, and states involved are expected to comply, though enforcement, as we'll see with all of these, can sometimes be quite difficult. And secondly, it issues advisory opinions, so even if states don't consent to it and don't bring cases to the ICJ, it can issue advisory opinions which are non-binding, unlike, theoretically, when it settles disputes and adjudicates, they are binding, though states can sometimes simply turn around and say no, they're supposed to be binding. But advisory opinions aren't. They could make advisory opinions on international law. For example, some of Russia's actions in Ukraine after invading Ukraine, Russia didn't consent to being a member of the International Court of Justice or for the ICJ to adjudicate, but the ICJ still issued an advisory opinion stating that Russia should stop committing war crimes in Ukraine and stop its military action. So then, how much influence does the ICJ have? On the one hand, you have arguments that it has very limited influence, and that's crucially due to the fact that states must consent to its jurisdiction for disputes to be heard and for rulings to be enforced. So if a state decides not to consent to the ICJ's jurisdiction, and it's committing war crimes, committing human rights abuses, or breaking international law more generally, then the court ultimately can't do anything. Crucially, even if the state kind of consents to its jurisdiction, if it gets a ruling that it doesn't like, it can also just decide then not to implement its rulings, as that's the nature of international law. There isn't a global police force, and there's very few mechanisms because of that lack of a global police force then to compel compliance. So Russia, China, and the United States, the most powerful states in the world, among others, don't permanently recognise the ICJ's jurisdiction. So the ICJ can only rule in a case involving them if they consent on a case-by-case basis. And if it's in a case where they're being accused of human rights abuses or they're being accused of breaking international law, they're very unlikely to. Crucially, advisory opinions are also even less powerful due to the fact that they're non-binding. And it can therefore overall be argued that the ICJ really has actually limited impact to uphold international law, international human rights law, and compel states to action. There's a few examples we can look at here. So I already spoke about the Russia and Ukraine example, the advisory opinion. There's a really interesting one in relation to Myanmar and Rohingya and the Rohingya genocide. So in 2019, the Gambia, this is showing this is a separate state, brought a case against Myanmar, so they're both permanently accepted the jurisdiction of the ICJ. And it accused it of committing acts of genocide against the Rohingya Muslim population in violation of the Convention of the Prevention and Punishment of the Crime of Genocide, which was one of those international human rights laws we had a look at earlier. The ICJ issued a provisional ruling ordering Myanmar to take immediate action to protect the Rohingya from further harm. But despite this, Myanmar's government really failed to comply in any meaningful terms. And this shows the court's limited enforcement capabilities, even if a state accepts its jurisdiction. A final really important example I think we can use is the lack of action against the United States. So following 9/11, the United States launched the war on terror, leading to military interventions in Iraq, Afghanistan in particular. And there were a number of really high-profile reports that continued to be of human rights abuses, including torture and indefinite detention, such as in Guantanamo Bay, Abu Ghraib prison. And this raised significant concerns under international law, and there was a lot of international condemnation by, for example, international human rights groups and pressure groups in particular. But despite this, no case was brought against the US to the International Court of Justice. Of course, as it's not a permanent member, it likely wouldn't have accepted it anyway, but the fact it wasn't brought shows how powerful states can avoid accountability for human rights abuses, as no small state would want to bring against the United States and threaten kind of potential retaliatory action, which could really harm their economy and their politics. On the other hand, then, there are some arguments that the ICJ does have significant influence and it is important. And that's firstly that its rulings carry significant moral and political weight, creating pressure on states to comply. So even though states could decide not to comply, often they do. And there's a couple of examples here. For example, a dispute over the San Juan River between Costa Rica and Nicaragua, where Costa Rica was ruled in favour of, and Nicaragua had to compensate Costa Rica for environmental damage, and both sides ultimately complied with the ruling. And you see exactly the same in a ruling between the Democratic Republic of the Congo and Uganda in 2022, in response to kind of historical Ugandan military intervention in the DRC. And Uganda complied with a ruling that argued the judge that it had broken international law, and it paid compensation to the DRC as a result. The next international human rights court we're going to have a look at is the International Criminal Court, the ICC. So then, what is the International Criminal Court? So it's an independent judicial body established to prosecute individuals for the most serious violations of human rights, so including war crimes, crimes against humanity, and crimes of aggression. It was created through the Rome Statute in 1998 and has been operational since 2002. As with the ICJ, it's headquartered in The Hague. Unlike the ICJ, which handles disputes between states, the ICC focuses specifically on holding individuals' accountability, so individual criminal accountability, and that makes it a unique mechanism for upholding human rights on a global scale. So, its mission is to really end impunity for perpetrators of human rights abuses and promote justice, and it has jurisdiction over crimes committed by in member states or by nationals of member states, and can also accept cases referred by the UN Security Council. So, the ICC can initiate investigations, based on referrals from member states, the UN Security Council, or at the correct request of its prosecutor with judicial approval. Cases can involve high-profile government officials, military leaders, or others who have committed grave violations of human rights. One notable feature is its emphasis on victim participation, so victims can contribute their views and concerns during proceedings and may receive reparations following a conviction. And that shows its kind of real emphasis on individual accountability and the nature of war crimes and upholding those rather than it just being adjudicated between states as the ICJ does. So how much influence does the ICC have? On the one hand, you have some arguments that it has limited influence, and that's crucially the fact that it depends on the cooperation of member states to execute arrest warrants and facilitate investigations. So if member states decide not to comply to execute an arrest warrant, or it's not in a member state, they can often have struggled to investigate war crimes or uphold convictions. For example, despite being convicted, Omar al-Bashir, the former president of Sudan, avoided arrest for years, as several states, including South Africa, Kenya, and Jordan, refused to enforce the warrant when he was visiting their countries. The second key argument, this is for me the most important, is that 70 states have not signed the Rome Statute and aren't members of the International Criminal Court, and therefore individuals from these countries, including government officials, can't be prosecuted by the ICC. And that's the key reason why they decided not to sign the Rome Statute, because they're worried that their government officials will be. And that includes high-profile states like the US, China, and Russia. Crucially, they don't want their government officials to be prosecuted for human rights abuses. So the ICC doesn't have jurisdiction over these countries and can't act against individuals from these nations. And as Russia, China, and the US are also members of the UN Security Council, it also means that the UN Security Council is very unlikely to recommend prosecutions against them or any of their close allies, as the UN Security Council can recommend prosecutions against non-member states, but because of the power of these countries, that's really defunct as a method of the ICC. This crucially undermines the court's universal mandate and creates a perception of selective justice, particularly against the world's weaker states. This can very much be seen in the actions of the ICC, which has disproportionately targeted leaders from weaker or developing countries, especially within Africa, despite human rights abuses occurring globally. So up until 2023, all 31 individuals publicly indicted by the ICC were from African nations, including Uganda, the DRC, Sudan, the Central African Republic, Kenya, Libya, Cote d'Ivoire, and Mali. This has resulted in many African Union states threatening to withdraw from the ICC due to allegations of bias, and it's not upholding human rights abuses globally against all states, it's only upholding them against African states. On the other hand, you have some arguments that the ICC does have significant influence and is effective. That's firstly that the ICC allows perpetrators of war crimes to be directly held accountable, which acts as a significant deterrent against future violations. So the knowledge that violations, regardless of their political power, regardless of their political power, could be prosecuted and personally held liable for human rights violations, can act as a deterrent and help reinforce adherence to international human rights law. Secondly, the ICC can be argued to have demonstrated its effectiveness through successful convictions and punishment of individuals who have committed war crimes. So it's secured convictions against 10 individuals, all of whom have been sentenced to imprisonment, and many of these are serving sentences, including Thomas Lubanga, who was convicted in 2012 for recruiting child soldiers, and Dominic Ongwen, who was convicted in 2021 for crimes including murder and sexual enslavement as a former commander of Uganda's Lord Resistance Army. On the other hand, though, you could point to the fact that actually 10 convictions against 10 individuals is incredibly low for a court that's been running for over 20 years now. A third argument, this is a really a more recent counter to the argument that it only focused on African countries, and this therefore really has a form of selective justice, is that in 2023 and 2024, it demonstrated that it doesn't just. So the ICC issued an arrest warrant for Russian President Vladimir Putin for alleged war crimes related to the conflict in Ukraine. It was able to, as Ukraine, where the alleged crimes took place, had signed the Rome Statute, even if Russia hadn't. Additionally, it's issued arrest warrants for Israeli Prime Minister Benjamin Netanyahu and former Defense Minister Yoav Gallant, as well as Hamas leaders Yahya Sinwar, who's now been killed, Mohammed Deif, and Ismail Haniyeh for alleged war crimes and crimes against humanity in Gaza. And it was able to do so again as a Palestinian territory to sign the Rome Statute, even if Israel hasn't. So yeah, there's some arguments on either side. What we're going to have a look at now is a number of case studies of the ICC, some of which kind of support the argument that it's ineffective and has little power, and some of which support the other side of the argument. The first case study then showing that it's ineffective is its investigation against Philippines President Rodrigo Duterte. So it began in 2018 investigating in the Philippines for Duterte's war on drugs, which have resulted in thousands of extrajudicial killings. And in response, Duterte simply withdrew from the ICC, which took effect in 2019. So although the ICC ruled in 2021 that it retained jurisdiction over alleged crimes committed while the Philippines was a member, the lack of cooperation for the Philippine government has stalled the investigation. It's really had little impact. And the fact that a country can just withdraw from the ICC when it gets investigated showcases the difficulties of the ICC in enforcing international human rights law, and how sovereignty can be used to evade accountability, and how international human rights law is often really difficult to uphold and therefore ineffective. A second case study is China's Uyghur genocide. So it's faced significant limitations, the ICC, in investigating a number of war crimes across the globe in human rights abuses. In a number of countries, but one of these is China, because it's not a member of the Rome Statute. So there have been severe allegations, a lot of evidence that China has been committing a genocide against the Uyghur Muslim population in Xinjiang for a number of years. So despite reports of mass detentions and severe human rights abuses, the ICC, though, has been unable to open a formal investigation as China isn't a member of the Rome Statute. And this really shows how the ICC is limited by its reliance on state membership and state willingness to become a member of the Rome Statute, which they're of course not going to do if they're going to get prosecuted. Third case study is we have an arrest warrant against Vladimir Putin. So as I kind of went through in 2023, the ICC issued an arrest warrant for Putin for alleged war crimes related to the forced deportation of Ukrainian children during Russia's war in Ukraine. And this was a significant moment for the ICC, showing its commitment to holding leaders accountable that weren't just from African nations. But despite the arrest warrant, Putin's evaded arrest and continued with his invasion of Ukraine, primarily because Russia isn't party to the Rome Statute. So that's why he's been able to avoid arrest and doesn't recognise the ICC's jurisdiction. So without the cooperation of Russian authorities or significant international pressure, the warrant remains unenforced. And that really shows the limitations of international human rights law in the ICC, because it doesn't have a global police force or courts to enforce its rulings. On the other hand, though, we have a final case study that kind of paints the ICC in a more positive light and shows that it can in some ways be effective, and that's the conviction of Thomas Lubanga. So in 2012, the ICC secured its first ever conviction in the case against Lubanga, a former leader of the Union of Congolese Patriots in the DRC. He was found guilty of war crimes, specifically for enlisting and conscripting child soldiers, and his conviction demonstrated the court could bring justice for victims, and reinforced the message that perpetrators of war crimes, regardless of their position, could be held accountable. So it shows the effectiveness of the ICC in holding individuals directly responsible for human rights abuses. So he's sentenced to 14 years in prison, which he served, showing the ICC's capacity not only to secure convictions, but also to ensure the enforcement of sentences. So that was the ICC. What we're going to have a look at now is the European Court of Human Rights. So the ECHR is based in Strasbourg in France, and it's the international court established to oversee the enforcement of the European Convention of Human Rights, which we saw was signed and set up in 1950. Its primary role is to ensure that member states uphold the civil and political rights enshrined in the Convention, and it has jurisdiction over members of the Council of Europe, which include over 46 countries. And this isn't an EU an EU institution, and it includes non-member states such as Turkey and the United Kingdom. What then does it do? So crucially, the court's most notable and unique function is that individuals can bring cases directly to the ECHR for alleged violations by states under the convention. And this empowers citizens to hold their governments accountable for human rights breaches, and that really differentiates it, for example, from the ICJ, where only states can bring cases against states. Here, individuals or groups of individuals can bring cases against states for human rights abuses against them. You can also hear cases brought by one state against another, but this is less common. And crucially, decisions made by the ECHR are binding, and member states are required to comply with the court's rulings. They will, of course, look at how effective that is in a bit. So then, how much influence does the ECHR? On the one hand, you have some arguments that it has significant influence, and that's that despite challenges, it's played a transformative role in shaping human rights law across Europe. Its judgments have led to legal and policy reforms in a number of countries that have improved the upholding of human rights, and its ability to hear individual complaints ensures a level of accountability that's unique among international courts. On the other hand, crucially, its effectiveness is hampered by non-compliance. So while the court's rulings are legally binding, enforcement depends on the political will and cooperation of the member state, and that's because of sovereignty, because as we mentioned at the top of the video, the fact that international law doesn't have a police force to implement it means it's really dependent on voluntary compliance by states. We'll have a look at this in a number of case studies then. First, looking at some that really show the effectiveness of the ECHR in upholding human rights. The first of these is Goodwin versus the United Kingdom, where the ECHR ruled that the UK's failure to legally recognise a transgender woman's gender reassignment violated her rights to respect for a private life. And following the judgment, the UK implemented significant legal reforms to kind of ensure that its law was updated to be compliant with the ECHR, including the enactment of the Gender Recognition Act of 2004, which allowed transgender individuals to obtain legal recognition of their gender. And this highlighted the ECHR's role in advancing LGBTQ+ rights and pressuring states to align national laws with international human rights standards. There's another example here of that in Cillian versus France in 2005, where the ECHR ruled that France had failed to protect a young Togolese girl who had been subject to forced domestic labour and servitude, therefore violating Article 4 of the ECHR, which prohibits slavery and forced labour. And it found that although French criminal law addressed human trafficking, it didn't adequately protect individuals from conditions amounting to servitude and effectively slavery. And this not only raised awareness of modern slavery within Europe, it also led to France revising its laws to provide clearer definitions and stronger protections against forced labour. And it shows, again, the effectiveness of the ECHR in driving legal reforms within member states. On the other hand, then, you've got a number of case studies showing the ineffectiveness of the ECHR. So Russia has kind of routinely not complied with ECHR rulings. So before it was actually expelled for kind of the invasion of Ukraine in 2022, Russia routinely ignored rulings, particularly in cases related to political prisoners, freedom of expression, and human rights abuses in Chechnya. And its consistent refusal to implement decisions highlights the limitations of the ECHR's reliance on the political will of member states for compliance. So even if rulings are theoretically legally binding, they still rely on member states to implement them. And that shows how sovereignty and the reliance on the voluntary cooperation of member states is a hindrance to the upholding of international human rights globally. Finally, Hurst versus the United Kingdom. So in this case, the ECHR ruled that the UK's blanket ban on prisoner voting was a violation of the right to free elections. And although the judgment emphasised the need for legislative reform, the UK in this case has decided not to introduce new laws. And this shows, again, how the ECHR may not be upheld and human rights may not be upheld by a member state if it clashes with domestic political considerations, again highlighting how sovereignty and political considerations can really be detrimental to the upholding of human rights. The final type of court we're going to have a look at then is International Criminal Tribunals. So they're judicial bodies that are established specifically to address violations of international law in specific cases. So they're created through the UN Security Council resolutions or international agreements, and they investigate crimes, conduct trials, issue judgments, and impose sentences. and they're supposed to uphold justice and promote accountability in relation to a particular conflict. So there have been 4 major international tribunals initiated by the UNSC or related agreements. The International Criminal Tribunal for the former Yugoslavia, which was established in 1993. The International Criminal Tribunal for Rwanda, related to the genocide in Rwanda. It was formed in 1994. Special Court for Sierra Leone, and the Extraordinary Chambers in the Courts of Cambodia. So we have some arguments on either side here before we look at some of those, a couple of those case studies in more detail. On the first hand, we have some arguments they are effective, and that they've been effective and successful in achieving justice and accountability by prosecuting high-profile figures that have committed human rights violations, similar to the ICC. Tribunals can also act as deterrents, and they've played a crucial role in developing international law by establishing important legal definitions. So the Criminal Tribunal in Yugoslavia, for example, helped codify the definition of crimes such as genocide and clarified the command responsibility doctrine. On the other hand, you have some arguments that international tribunals are ineffective, and that's that there's bias, and arguments that they focus on specific conflicts whilst failing to address others. They've also faced criticism for being expensive and slow. So the International Criminal Tribunal in Rwanda, for example, was operational for 20 years, and some trials took several years to complete. And crucially, while tribunals can issue rulings, they rely on member states for enforcement, including arresting suspects. So the International Criminal Tribunal for Yugoslavia failed to apprehend Ratko Mladic until 2011, as he was protected by nationalist sympathizers within Bosnia and Herzegovina and Serbia. And that really shows the fact that they don't have their own enforcement mechanisms can limit their ability to uphold human rights. So now we'll look at a couple of these in more detail, and these are kind of the most prominent ones that you're going to be using in your essays. And the first of these is the International Criminal Tribunal for the former Yugoslavia, which is established by the UN Security Council in 1993 to address crimes committed during the Balkan conflicts of the 1990s. In total, it convicted 90 war criminals that can be seen as really effective. And one of its most significant cases involved Radovan Karadzic, the former president of the Republic of Srpska, who was charged with genocide, war crimes, and crimes against humanity related to the Bosnian War. It found him guilty in 2016, sentencing to 40 years in prison for orchestrating atrocities, including the Srebrenica massacre, where over 8,000 Bosniak men and boys were killed. It played a crucial role, therefore, in holding powerful figures accountable, establishing that individuals in positions of high authority could still face justice for severe human rights abuses despite their power. And it was significant in reinforcing international legal standards such as genocide and command responsibility. And although it faced challenges, as we looked at, such as delays in capturing high-profile suspects, it ultimately demonstrated the effectiveness of international mechanisms, international criminal tribunals, in prosecuting war crimes. Very similar in the Tribunal for Rwanda. It was in relation to the genocide in Rwanda in the 1990s, where approximately 800,000 people died within or killed within 100 days. And one of the most notable cases was that of John Paul Akaseyu, a former mayor who became the first individual to be convicted of genocide by an international tribunal. It found him guilty of genocide and crimes against humanity, including acts of sexual violence, marking a historic moment by establishing that rape could constitute an act of genocide when used as part of a systemic attack on a group. So that also really updated international law and international human rights law as a result of the tribunal. So it set a precedent for how gender-based violence is prosecuted in the context of mass atrocities, and it highlighted the importance of accountability in post-conflict justice, demonstrating the tribunal's role in developing international legal standards. So it was criticised for slow processes, but the conviction of figures like Akaseyu shows its effectiveness in addressing impunity and contributing to the legacy of international criminal justice. So they were the 4 key international human rights courts that we have to have a look at, including some key case studies and arguments on either side. What I'm going to look at now, finally, is some more general arguments on either side in relation to the effectiveness of human rights law being upheld due to state sovereignty. So the relationship between human rights law and state sovereignty is really complicated in human rights courts in particular. It undermines sovereignty for some states more than others, and only sometimes needs to do so for it to be effective. So there's 4 key perspectives we're going to have a look at. And the first one is that sovereignty does stop human rights law from being effective, as human rights law is very dependent on states to enforce it. So this would crucially be an argument made by realists, who argue that international human rights law doesn't undermine state sovereignty, and that state sovereignty in fact stops international human rights law from being effective, as nation states are the most important and powerful actors in global politics, and they can simply say no to an international court or an international organisation. So as international law doesn't have enforcement mechanisms such as police forces or judicial oversight, international human rights law depends on states to voluntarily accept rulings motivated by their own interests. And they will do so if it's in line with their interests. This is what realists argue. They'll only do so if it's in line with their interests, and actually refuse if it's not in their interests, which is almost always going to be the case when they're asked to enforce rulings against themselves. And that shows how sovereignty limits the effectiveness of international human rights law. So whilst the ICJ, ICC and ECHR can issue quote-unquote legally binding rulings, they have no real powers to enforce these rulings if the state decides not to comply. And that really shows how sovereignty stops international human rights law from being effective. We've got another key argument that sovereignty stops international human rights law from being effective, and that's actually that powerful states can simply ignore it. So this is the argument that international human rights law has a selective impact, where it undermines the sovereignty of weaker states, as there's more pressure on them to comply, whilst powerful states retain their sovereignty and ignore it. So it's often really effective in influencing less powerful states due to the international pressure and potential repercussions for not accepting the jurisdiction of international courts. There's more pressure on them, and as they're weaker, they're more forced to accept jurisdiction and therefore accept rulings. On the other hand, though, more powerful states can ignore these pressures without consequence and decide not to accept the jurisdiction of international courts or accept their rulings. That can be seen in the ICC, where Russia, China, and the United States, the 3 kind of most powerful states in global politics, have decided not to sign the Rome Statute, and therefore the ICC can't prosecute their leaders for war crimes. And by contrast, the majority of the world's poorer and weaker states have been pressured by liberal states, in particular the European Union actually, to sign the Rome Statute. And all convictions made by the ICC so far have been against citizens of African states. This really shows that the liberal idea of international human rights law as being indivisible and protecting all citizens equally is fundamentally flawed and isn't upheld globally. On the other hand, then, we have some arguments that human rights law can be effective, and that it sometimes is effective and undermines state sovereignty to be so. So there are, of course, significant challenges in enforcing human rights law, but there are instances where international legal institutions such as the ECHR, the ICC and the ICJ have successfully held states accountable, and therefore undermining complete state sovereignty. States have been kind of forced to comply, or there's been enough pressure on them to comply with these rulings, even if they're not necessarily in their interests, which realists really focus on. So the liberal perspective argues that this type of enforcement is justified because it prioritises the protection of human rights over the absolute power of state sovereignty, and liberals maintain that human rights are universal and must be upheld even if it means reducing state sovereignty. So international courts such as the ECHR have demonstrated the ability to compel states to alter their laws and policies in response to rulings. For example, as we looked at in Goodwin versus the United Kingdom, where the UK subsequently enacted the Gender Recognition Act of 2004. The final argument then is that human rights law is sometimes effective without undermining state sovereignty. This is a different perspective, and it argues that human rights law is often effective, but it's largely actually due to the voluntary compliance of states rather than the states being forced to comply, and therefore it doesn't undermine their state sovereignty. So states often adhere to international human rights norms because doing so aligns with their values and enhances their global reputation, rather than because they're forced to by an international court. And this liberal perspective supports the view, arguing that international cooperation and shared norms encourage states to uphold human rights without direct compelling them to do so. And this does mean that the effectiveness of human rights law is dependent on the willingness of states to act against their interests, which realists would contend is rare. And you can see this, for example, in the fact that the ECR's judgments often lead to state compliance because of the reputational benefits of being seen as a protector of human rights within Europe. So yeah, that was a pretty long video, but we first gave you an introduction to international human rights before looking at 4 key international human rights courts and some arguments on either side in relation to sovereignty. So these kind of arguments at the end, you can bring various ones into your essays on different sides. You don't have to use all of them. but they can be really useful arguments, particularly in relation to questions on human rights and sovereignty. Please let me know in the comment section if you've got any comments or questions, and I'll get back to you, and I'll see you in the next video.